Good morning. Thank you for the introduction, David. I'm Janice Bereskin. As David mentioned, I'm a partner at Bereskin & Parr in our Toronto office, and I proudly co-lead our firm's trademark group. And this is my third year at the McCarthy Institute, and it's terrific to be involved again this year. And we've got a full house, and I don't know how we got so lucky having been given the first session, so thank you. When I'm not working, and I've asked this question for all our panelists, I'm going to tell you a few things about myself that I like to do when I'm not working. I don't curl, but I do know all about curling. And in fact, our firm actually used to have an annual curling day. But I love to play tennis, spend time outdoors, not particularly during our Canadian winter, but also being a very proud Canadian and a mom. I'm a hockey mom. So. So today, before I do our panel introductions, we've got 5 questions for our panelists. So hopefully we'll have time for everybody to answer. And we're going to save some questions at the end for all of you. And we're around the rest of the day as well. So with permission of my panelists, the introductions will be brief. Their full bios are in your printed program. First, we've got Megan Bannigan to my left. Megan is counsel at Debevoise and Plimpton in New York City, focusing on IP litigation. And she's also an adjunct professor at Rutgers University teaching fashion law. In her spare time, she also likes to spend time outdoors, kayaking, paddleboarding, snowboarding, and cooking. But she told me that in reality, most of her free time these days is spent chasing after her 1-year-old son. And this is a recurring theme, by the way. Next to Megan, on my left, we have Angela Dunning. And Angela is a litigation partner at Cooley here in Palo Alto. And she represented Google in the ELLIOTT case, defending Google on genericide grounds. And you'll hear a little bit more about that in our session. And in her spare time, not to outdo me or Megan, she enjoys taking her 4 kids around to parks and museums around the Bay Area and enjoys seeing movies of all genres. I don't know how you have any spare time with 4 kids. On my far right is Joe Ferretti. Joe is the VP and Chief Counsel of Global Snacks Group and Global Trademarks at PepsiCo Inc. in Plano, Texas. And prior to joining Pepsi, Joe was a partner at the firm Crowe and Dunleavy in Oklahoma. You'll notice his strong Oklahoma accent. And Joe holds an LLM in intellectual property from the University of New Hampshire, Franklin Pierce Center for IP. And Joe is very active with the INTA, and in fact, he was the president of INTA in 2017. And when Joe's not working, he enjoys hiking, biking, and cheering on OU college football games. And finally, my friend Elena Grimm. Elena is the Assistant General Counsel at Microsoft and the head of the Trademark Group. Prior to moving to Seattle for this role, Elena was based in Milan and responsible for Microsoft's anti-piracy programs in Europe. She also holds an LLM from the University of New Hampshire, Franklin Pierce Law Center, but I don't think you were there at the same time as Joe.
1 year.
And Elena also recently served on the INTA Board of Directors. And when she's not working, she enjoys skiing and playing tennis, cooking, eating, and drinking. But she also, a notable distinction, but also like Megan and Angela, she's got a 1-year-old daughter, which takes up most of her free time. And we were supposed to have another panelist today, Rafa Gutierrez from Uber, and unfortunately he's fallen ill with the flu. So we agreed with his decision not to be here and spread his germs. So, okay, so let's get started. I guess this is my clicker for the presentation. Let's see. Okay, so question 1. What cultural shifts or trends have you seen in trademarks in the past and present? Now that we could just take up the whole session talking about that, but why don't we let Joe start with this?
Thank you very much. There we go. Okay.
So before we talk about trends and changes and where we're going, we ought to back up a little bit, take a step back, even though most everyone in this room is kind of familiar with this, including probably Ellen Taylor. She probably understands all about trademark rights and where they start. But those few of those who don't here, law students, whatever, I think it's at least a good point, and that is, that trademarks have a potentially infinite lifespan, and that we can renew them throughout. So here's a couple examples of trademarks that were from before the 1900s. But we can also update our trademarks, and the law allows this, right? They need to modernize over time. And here's some examples from my company of how the trademarks have been updated. But do keep in mind, it's jumping from one log to the next, right? It's you leave one in the past and you move to the future, and that's the traditional trend. And I'll show some more examples just to kind of go through. Again, this is from my company. It kind of does look like the same person was in charge of the logo on the first top part, and the same person was on the bottom part. The changes seem a little less, but so that's what brands do. Morton Salt did it, of course, as well, and they updated the Morton Salt girl over time. And then Betty Crocker has done that as well. And she's changed to modernize with the times, right? Okay. Kind of, no bow. Now at the very end, you kind of get into, it looks like a necklace of some sort. And so these are examples of how we're able to do that. But again, it's been pretty static, right? You stay with one and then you move on to the next. So then that kind of brings us to today. And I think Google's probably the perfect example of, what's happened in that regard. Well, the trademark owners today, like Google and others, they're kind of breaking this conventional wisdom, this conventional perception that the best way to establish your brand is to use the same presentation over and over, and then it just makes a big impact on consumers' mindset. And so, but today, the new generations, and particularly with the digital media, they've changed this, and accordingly, I would say that consumers' mindsets change as well. But it's not a new trend. If we remember, go back to Russ when you were in 7th and 8th grade watching MTV, this is a lot of what you saw. So it's not a brand new trend. It's been going on for a while, but it's become a lot more fashionable today than it really ever has. There's probably examples before that, but would kind of predate my knowledge. And then here's another example where the trademarks, they're not presented solely kind of in a uniform format, but they're intentionally dynamic and interactive with consumers. And that really demonstrates the difference between a traditional way of doing things in one single representation to do it more in a fluid sense. And when we talk to our clients or in-house, the marketers, what do they want to do today? Today, they really focused on establishing an emotional connection with consumers. And to do that, they don't want to present marks, trademarks, et cetera, in a uniform fashion, but instead they want to maintain it dynamic. They want to connect with the consumers between the brands with those consumers. And so their goal is to develop a long-term relationship between customers and their favorite brands, and fluid marks allow it. They allow the brands to also provide messages, such as here, or with Google. Google does it I don't know if it's every day, but frequently. They're providing a message, generally kind of what's going on in the world this day, or perhaps an anniversary of someone's birthday, or so on and so forth. So it is a communication piece. Snickers is doing it as well. They're communicating through the different words that they put on package. And because of that, we've become a lot more flexible, I would say. Flexible in terms of using our trademarks in a non-traditional way, because instead of, we're now providing messages to consumers, but the mark can also sometimes become part of the message. And that wasn't happening, a number of years ago, where they become part of the message, and it allows your brand to further connect with consumers. Obviously, we have to do this in a way that makes sense. We have to do it in terms of with guardrails, and that's really kind of what I wanted to talk about in terms of a best practice when we're doing fluid marks, because I would say 5 or so years ago, there was a big discussion about fluid marks. And it seemed to be, should you do it? Should you not do it? And I would pretty much submit that the train's left the station on that. But you still have to do it the right way. You still have to protect your brand. And when the old adage, consistency is key, that's still, I would submit that still exists today in one shape or form. It doesn't mean it has to be consistent all the time or prevent fluid marks. So how do you do it? I think you start with a strong brand, and you register that strong brand. And in that way, you can maintain your rights, your registered rights. You can go enforce it against others. And you also are going to want to, and I think that you can make the case, at least in the US, that you're expanding the rights of your brand. So if you look at the Snickers situation, people start to identify that logo without having to rely upon the Snickers brand. So I think that there's consumers have already got there, and so lawyers kind of have to acknowledge that trend. But you should also do it in a way, I would submit, that where you continue to use that primary mark. And in the Snickers example, they still have Snickers on pack, okay? Or Absolute Vodka. They still use their main trademarks, even though they'll do things in a fluid way. You go to the Google website. On a day when the Google Doodle has not changed, it'll be the normal standard Google trademark. And adopting a signature style is kind of the best way to protect it. And you keep the identity kind of in the same way, no matter how you're using it, but you should use all of the resources available for you to protect it. And copyright is certainly kind of the most obvious to help you enforce the different style as you change variations. Intel last year passed a resolution, in fact, to encourage the Copyright Office to allow registration of copyrights that are also trademarks, because of course you have both aspects. Other best practices, of course, you want to clear the variations so you don't infringe third-party rights, which Google has done. And then you have to be prepared for parodies because that's going to happen. And MTV saw it, and I don't know if they still do. I don't really watch MTV anymore. Nothing against it. Okay, so, and then the final trend is this. The final trend is we're starting to see the designers and marketers go to clean trademarks and clean logos. Well, what does that do for us as trademark practitioners? Well, we kind of, it kind of makes us concerned because a lot of the distinctive elements can go away, and therefore can make it harder to protect. I've got kind of 3 or 4 slides to show in that regard. Here's a situation where they've updated their trademarks without the logos. Now that's concerning, right? Because a logo can immediately identify with consumers. We can all probably remember, or at least I do with my son who was 3 years old in his car seat in the back, and we're driving down the road and he says, there's Starbucks or there's Target. He can't read, but he can identify with the strong communication of a logo. So when you go clean and simple and you get rid of your logo, there's concerns from a trademark lawyer perspective. You can update your logo. And it's here are examples of when it's being done in a clean, kind of in simple way, right? And there's a curling reference. Exactly, curling Canada. But they utilized, which was great, and from an attorney perspective, what we care about, they utilized the main elements of their old logo, and that's important. Here's a situation where they've updated their trademarks or they've even changed the logos. Like look at Colorado, for example. I would submit that Colorado had a lot of goodwill with that logo, and they went to a different one that really more reflects what's on the license plate. But you see situations like Century, where there's an icon there, Yeah, and as a lawyer, you don't want them to get rid of that, so we work with our clients to ensure it's being used somewhere. Same with Reebok, where they changed the logo. I got it. Okay. I did put a Canadian hurling up there. So then, what's the best practice in this regard? It's to work with your marketing group, work with the design group, identify what are the distinctive elements of the logo or of the trademark. And here's a situation where Budweiser, you can see in the former logo, it seemed that the crown was part of the logo, and it looks like to me that the lawyers kind of got with the designers and said, we still want to use that. We don't want to lose the rights on that product. So let's put it somewhere where we can maintain the rights, even though we've disassociated those two pieces, because we may go back to it. So from a best practices standpoint, I think that if you can get with your client early, talk about what's distinctive, demonstrate to them by removing the distinctive elements, kind of what's left from an enforcement standpoint.
Okay, thanks, Joe. You covered a lot of ground there, but there's a few other areas to cover when we look back on past trends and what we're seeing presently. Megan, why don't you take it from here? Oh, you need the clicker, sorry. And we can talk about things like, color trademarks, maybe scent, sound marks, and we'll see if our sample sound marks work.
That's a big question. Thank you. Okay. So we can go through some of this pretty quickly because, a lot of it, most of us already know here in this room. But in terms of cultural shifts with color marks, there were some shifts, but really those happened years ago. Historically, the PTO did not allow registration of single color marks, but that obviously all changed in 1985 when the Federal Circuit recognized pink for fiberglass insulation products. And the Supreme Court affirmed that a decade later, recognizing or agreeing to register green for dry cleaning pads. Since that time, there have been a wealth of single color marks registered from a lot of famous ones, which you'll see up here, and I'm sure you all recognize and know about. But that being said, color marks, they are difficult to register, and they remain difficult to register, and that's because of the secondary meaning that you have to prove. A recent good example is the Cheerios. General Mills sought to register the yellow color for its cereal box. Along with its application, it submit a ton of evidence of secondary meaning, including evidence of historical use going back to the 40s, over $1 billion in advertising using the yellow packaging, jingles that talked about the yellow packaging, and a lot of unsolicited media attention. It also had a survey showing that over 48% of respondents associated the yellow box with its Cheerios. Nevertheless, the TTAB affirmed the denial of the registration on the grounds of all of the other cereal boxes that also use yellow. So if you're looking to register a color mark, not only do you have to show that consumers recognize the color as a source identifier of your mark, but that you have substantially exclusive use. And that's something also to think about when you're enforcing your color marks. Look at who else is using that color and consider enforcing, taking some action. Even if you do get a registration in these color marks, that doesn't necessarily mean they're going to be enforceable or you're not going to have problems down the line. And every year we're seeing more and more cases about color enter the courts. I mean, obviously there is a few years back, there is the high profile Louboutin case where Louboutin went after YSL and ended up getting its trademark registration and its red sole shoes narrowed. The Louboutin trademark issues, they still continue with the recent CJEU Advocate General expressing doubt that the registration is viable in Europe. So that's one to watch. A recent case that I worked on involving color was the PayPal v. Pandora case, which PayPal filed in the Southern District of New York last year. What happened was Pandora rebranded with this big blue chunky P that you see in the middle here. And PayPal and lots of PayPal's customers certainly found that confusing, especially when you look at it in the mobile phone icon context, where so many people use Pandora and PayPal. Social media went ablaze with comments, with people expressing confusion and frustration. Suddenly they were clicking on, they thought they were buying something, and songs started playing. These are just some examples that were cited in the complaint. This case was resolved, and unfortunately I'm not at liberty to talk about the resolution, but this brings a really interesting issue, because as consumers, we're so dependent on our mobile phones these days. We really look at them to guide every aspect of our lives. And these are putting brands next to each other that wouldn't ordinarily be next to each other or be in the same proximity. And you only have a very little space there to make your brand distinctive. It's really important to brands that it's not causing confusion or even just annoying their consumers. So it's really something brands need to think about going forward. And I'm sure they'll be grappling with it, and the courts will be grappling with it. This is the only case we're aware of that's been filed so far dealing with trademark infringement on mobile apps. So certainly something to watch going forward. And then really quickly, we can just mention sounds. There hasn't been any big cultural shifts with sounds, so to speak. They've been readily registerable since the 50s when they registered the sound for the 3-chime sound for NBC radio. There was a slight change back when Vertex attempted to register a pulsing alarm sound for use with its child abduction bracelet. I could play that for you now, but I'm actually not going to. I'll do you all a favor because it is quite annoying. And the TTAB said that if you use the sound in the course of the ordinary function of the good, you have to prove secondary meaning in order to get it registered. And that is obviously much more difficult to do. That being said, there are still plenty of sound marks that continue to be registered. Some of the recent popular ones is the Mockingjay whistle for Hunger Games, Apple's startup sound for Mac, and of course, Darth Vader's breathing sound. Scent marks, also not a huge cultural shift because they remain inherently difficult to register. There are actually less than 20 that have been registered. Some examples here, you have the plumeria smell for yarn. That was the first one registered. You have a pina colada smell for ukuleles. That was put on the supplemental registry. And then here, there's the Flowtech example, which didn't get registered. It tried to register an orange scent for fracking fluid. But the TTAB said because the chemical that caused that scent also had some functional benefits, it couldn't be registered. If you are considering registering a sound, the case to look at now or the registration to watch is the Play-Doh. Play-Doh last year filed for a registration for its scent. It had a very detailed description. That sounds almost more like a fine wine than Play-Doh, but so it goes. It initially didn't submit any evidence of secondary meaning, but received an office action, and in response submit a ton of evidence, including evidence of over 36,000 social media posts in 2 years alone talking about the scent. So just as of 2 weeks ago, it received a notice of publication, and that will be published next week. So, something to look at if you have a scent. Because there are so few scents registered, there have been no cases filed over scent infringement. And because to register a scent, they have to be so unique, you really have to consider, what is the actual benefit of registering a scent at all. I think that we have some more we could go on and on about, but I think we should move over to the tech side now.
So thank you. And I should mention that the scent is so appealing to kids for that Play-Doh that one of my kids started eating Play-Doh. And I'm happy to report that nothing terrible happened as a result. Elena, why don't you give us sort of a technologically focused perspective on how technology has affected trademarks, and we're here at Google, so what a place to start.
Yes, thank you. So as in-house, coming from the tech industry, I think one of the major cultural and social shifts that we experience is that tech is everywhere. I mean, everyone is in the tech business. You think about the products and services that you deal with on a day-to-day basis, they all have some technological aspect to them. Every business is embracing technology and innovation, or at least wants to be seen as embracing technology innovation. And it's remarkable to really see how technology in the past decades or two has come to transform the way we sell products, the way we play, the way we shop. And so what does this mean for a brand lawyer? Especially as, I'll give you the experience as in-house counsel for a tech company. So let's take, for example, the concept of Internet of Things. And as we're at Google and in Silicon Valley, so there isn't a more tech environment than this. But for the less tech-savvy people, by Internet of Things, we literally mean things that are connected to the internet, right? So a network of devices, tangible objects, that incorporate or have embedded some technology, sensors, chips, software that allows them to connect and share data. That you think about, your Fitbit, the heart rate monitor, the smartwatch, the doorbell that now has a webcam incorporated and that you can talk to through your smartphone, the thermostat that you can remotely change your heating settings from away. The car with the virtual driving assistant, right? So if you're one of these companies, you're the doorbell maker or the car manufacturer, you're either partnering with a tech company to develop that technology or that technological device, or you're making it yourself. But the point is that maybe as a car manufacturer or a doorbell maker, you're no longer just thinking, hey, my brand is going to be on a doorbell or my brand is going to be used for a car, but maybe you want to protect it also for software and computer hardware and similar and related services. And should you think about clearing it? I mean, can you use that brand for these related software and computer goods and services? And similarly, if you're a company that provides provides software as a service, like Google and Amazon and Microsoft and a myriad of other tech companies, now you get into experiencing your brand that is maybe more traditionally in the software and hardware space, potentially being used in totally different industries. So take the example of BMW, who uses the Microsoft Cloud Platform to provide connectivity services to its to the car drivers and users. Our cloud brand is Azure, right? Now, let's say that your engineering and marketing teams come up with the crazy idea and somehow convince BMW that they're going to etch Azure on the dashboard or somewhere visible on the car so that a consumer sees Azure now on the car. Is that use of Azure for a car? Or is it still, can we still make the case that actually Azure is being used in relation to cloud-related services? Or is the consumer perceiving it as use on the car? And do we have to go clear it? And what if there's a third-party manufacturer of cars in Spain or Korea that owns Azure for cars? Are they going to come after us? So those are all the types of questions that we have to face and deal with on a day-to-day basis.
And are they going to come after you in other countries?
Absolutely, because maybe in the US we could make a certain case in terms of the practical aspects, but good luck doing that in an Italian court, and I will say that because I'm Italian. Let's consider, moving on or in the same vein, if you think about artificial intelligence, again, by that term, we more or less mean technologies that allow computers to reason, to experience in a similar, and to make actually purchasing decisions in a way that is similar to human beings. So nowadays, computers learn like humans through experience, right? There's a Gartner study that predicts that by 2020, 85% of customer service interactions in the retail space will be powered or influenced by some form of AI technology. So let's think about AI as it comes to the retail space or in our purchasing decisions, and why is it relevant to trademark law? And there's some articles that were recently published that are very interesting on this very issue. If you think about it, at the foundation, trademark law is all about humans and human interactions with the brand. I mean, think about the elements that exist in many of the trademark laws around the world. You're talking about how the consumer experiences the brand in the marketplace, the imperfect recollection of the human, of the average consumer. If the consumer is confused by two brands, right? And now we are moving into an environment where a robot or a virtual assistant, and if something that an algorithm powered by artificial intelligence is taking over the purchasing decision, sometimes altogether, right? So it's removing any human factor from making that purchasing decision. What does that mean? I mean, when you tell your Alexa or Siri, you ask to buy sugar, or you ask to order a dollhouse for your daughter, does the AI, the algorithm, actually think about the brands, perceive brands? Does it take them into consideration? How does it discern from them? Does it get confused? Does an algorithm get confused between brands, and does it do so in the same way that a human would, right? Or should we teach it to be confused in the same way that a human would? And what if... No, and I apologize. I should have said in advance that I'm raising more questions than I'm providing answers. But lastly, if the virtual assistant orders and chooses a counterfeit, where does the liability lie, right? So all these questions. There's actually a lot of talk right now about the inevitable development of a body of law called AI law, just like the clear and precise body of privacy law that we now have today, and then maybe 30 years ago, especially in the United States, you wouldn't have thought of. Similarly, there's going to be a lot of development in this space, and it might be that as regards to trademark law, a lot of the existing regulations and laws and case law will learn to apply with these scenarios, or we'll just see some drastic changes. But it's just an interesting space. Okay. Sorry, one more. Sorry. Always in relation to bots, because this is a bit of a scary thing when you're supporting a business. As you know, you hear a lot about bots and chatbots, and essentially some of these might be just a computer or an algorithm that allows you to perform automated tasks on the internet. But sometimes bots get a personality, right? They're a virtual assistant, so they're given an identity, they're given a persona, a name, they're an appearance. And so from a trademark lawyer's perspective or a brand lawyer's perspective, the first implication of this is you can't not limit yourself to just looking at trademark law, because you've got a persona now, so you're going to have to think publicity rights, personality rights, and you're not just clearing the name. But the second most relevant and I think challenging aspect of this for us is the inevitable evolution of the bot, because the whole purpose of artificial intelligence behind these bots is so that they evolve and they develop and they change depending on how they interact with the users. So you can start with your business, you're counseling and you're deciding on a name, and because of the name and the looks, the risk is at a certain level, so you move forward, and then inevitably the bot will change, and because of its interactions with users might become too similar to a famous person, and end up creating legal risk. Imagine, for example, you're creating a bot that they want to call Bae, like a young millennial woman, and is going to interact on social media with users of the same age. And, Bae is a common nickname. It is a nickname for a famous person, but you think, okay, it's okay, well, let's move forward. And then suddenly, thanks to the interaction, this Bae starts speaking of songs like Deja Vu and Irreplaceable and Lemonade, and then a husband called Jay, and then what do you say? Okay, then now it looks like Beyonce. Do you tell your team, okay, take it down, or do you wait until it evolves into something different again, hoping that Beyonce doesn't recognize it? But worse, what if instead of looking like Beyonce, it starts interacting, because there are trolls and people who like to play with this stuff, and it suddenly becomes a bot that is praising from Hitler to the Ku Klux Klan and everything in between, and being offensive and scandalous. Because at that point, even though it's not close to Beyonce, if Beyonce becomes aware of it, she's not going to want any association with this, right? So that raises the practical risk of hearing from Beyonce to a very high level. And with that, I will stop here.
No. Okay. Oops.
Going to Angela.
Yeah, okay, so here we go. Our next question is, when a mark becomes so popular and immersed in culture, it can run the risk of becoming genericized. And how can a brand benefit from both the widespread use and popularity, but also protect it? And so, of course, I think our next slide, Angela, you can just click on that, is just a list of some trademarks which became generic in the United States. And I would point out that in other countries, a lot of these marks are still registered trademarks. So it does, yet another reminder that the laws do differ outside of the US. But Angela, why don't you take it from here?
Hi, everybody. So I'm Angela Dunning from Cooley. I had the distinct privilege and honor to represent Google in connection with the ELLIOTT case that was decided by the Ninth Circuit last year. And I would say this represents the most significant cultural shift in the area of genericide in recent time. I thought I'd tell you a little bit about the case since we're here at Google and we got what I think was such a fabulous result. The plaintiffs in the case had filed to register 763 domain names incorporating the Google mark for everything from GoogleBarackObama.com to Google Cartier and Google Disneyland and Google State Farm. They never provided a very good explanation for why they chose to do this, but in any event, Google, with the assistance of Gavin Charleston in-house and many others at our firm, brought a UDRP proceeding in which the panel decided that the use of the marks was infringing and that the domain name should be transferred back to Google. At that point, the case could have been over, but plaintiffs opted to file a federal action seeking a declaration of genericide as to the core Google brand, the registered mark for the Google search engine. This opened up a question that hadn't been looked at for a little while in terms of what it means to be generic. And I'll just point to there we go. So many marks, as Janice pointed out, over the years have suffered what is called genericide. They began as protected marks, but then lost protection when the public began to use them as the name of the good rather than an indication of source. You can see in these ads from Bayer early on that aspirin is really used as the name of the product itself with Bayer as the brand, which didn't bode well. I don't know how Bayer heroin did, but that's no longer for sale anymore. Bayer faced use of the term by many others as a name of the product. Folks didn't think salicylic acid ran off the tongue. So prior to the Google decision, a lot of companies were faced with the dilemma how to prevent their own marks from succumbing to genericide, especially as a brand becomes more popular and is used more ubiquitously in our everyday speech. Rollerblade, in this very simple ad, explained why using rollerblading would not be appropriate. Mixing those things would be even more dangerous. Frigidaire has a nice ad here as to why one should always use the circle R at the end of the mark. Clorox took out an ad informing the public that it's not just bleach, it's Clorox. Xerox said it gives you a headache when you use Xerox the way you use aspirin. And then we come to Google. So Google was confronted with an assertion by the plaintiffs that Google as a verb had become so common in our everyday lexicon that it no longer served as a brand. And the argument was the court should look to how it is most often used. The plaintiffs offered expert testimony and numerous citations to cartoons, TV shows, movies, rap lyrics, you name it, citing use of Google as a verb. Just to give you one example of an exhibit in our case, they're encyclopedias, Timmy. They're an early form of Google. Have you tried Googling it? I would Google that instantly if that ever befell me. The problem with these instances, as the court in the ELLIOTT case found, is that genericness is not assessed by reference to how we use marks in everyday speech. Rather, it's assessed by reference to a specific good or service. So the issue was not how do people most often use the word Google. The issue was how has the word Google become generic with respect to the Google search engine. Under the Lanham Act, a trademark is only generic if it is primarily understood as a generic name for the goods or services for which it is registered. And in this case, the only evidence that the plaintiffs had put forward is that Google is often used as a verb. It hadn't provided any evidence that it had ceased to serve its brand, its source identifying function, ceased to serve as a brand. The other main argument that the plaintiff made was that use as a verb was inherently generic, that verb use doesn't indicate a particular source, and therefore verb use is generic, and when a mark is primarily used as a verb, it must have become generic. But the court didn't buy that. The court said that verb use does not automatically constitute generic use because you cannot tell whether someone is using that word in a discriminate or indiscriminate way. When I say, I'm going to go Google that, I mean I'm going to use the Google search engine to conduct a search. I don't mean, with all due respect to my wonderful colleague at Microsoft, that I'm going to use to use Bing. And I think one of the important pieces of evidence in the case, nobody, not anybody in the media, no dictionary, not Google, and not Microsoft refers to Bing as a Google. That was absolutely clear evidence that Google had not become a generic term for any search engine. Rather, it continues to denote a specific search engine. So phrases like Google me and did you FedEx that letter and did you TiVo that program are not evidence of genericness without survey evidence or other probative evidence of what the internal thought process of the speaker was. When rapper T-Pain says, Google me, expletive, you don't know whether he's referring to Google or another search engine, although it's a pretty good bet he's referring to Google. And I just want to point out footnote 3, the Kleenex example. So the court gave this example of a Kleenex. People use that word also as a noun quite frequently, pass me a Kleenex. The court said in the case where someone asks for a Kleenex tissue, it's very obvious they're using that in a trademark sense. But when someone says, please pass me a Kleenex, you don't know how they're using it. That is unstated, and in fact, the presumption is often going to be that they're referring specifically to Kleenex, but without strong survey evidence of what that word has come to mean in the mind of consumers, it is not evidence in and of itself of genericness. And that's a big shift from how we used to think about these words. So what are some of the other key takeaways from the case? You're going to need, if in a genericness challenge, you're going to need solid survey evidence that demonstrates how people understand the term. The gold standard is still the Teflon survey. It's going to assess whether people understand that the mark is a brand or a common name. The court is not going to rely on grammatical formalism. The court is not going to look at whether it's used as a noun, whether it's used as a verb. Obviously, if you can keep the world referring to your products by their brands in the adjective sense, that's great, but it's not going to destroy your brands if they're used in everyday speech. The way we talk evolves, and brands maintain their strength through that everyday speech because they remain top of mind. They continue to evoke a particular product. And I will just say one other thing in terms of a practical tip. The plaintiffs tried the argument that Google's evidence of dictionaries and others in the market not using Google to describe other search engines was a result of bullying, that Google had gone out into the market and made people afraid to use it in that way, and that therefore it should count against Google's mark rather than in favor of protection. And the court dispensed with that. The court said efforts to police one's mark are absolutely essential and vital to mark holders' rights, and that demonstrates strength and protection, not genericness. So the conclusion, by all means, keep Googling, keep FedExing and UPSing and rollerblading and Xeroxing and Windexing, and then have a Pepsi, because that's not going to that's not going to affect the protectableness of the brand. That is actually going to continue its strength and contribute to its strength. Thank you.
That's great. Thanks, Angela. No, we're not done yet. No, we're not done till 11. That was just a passionate applause for, we still have till 11 o'clock. Okay, so let's move. We've got another question here for our panel. How has social media influenced trademarks? I mean, nowadays we're seeing hashtags for everything. We're seeing the second something happens in a world event or a social situation, the next day you see a trademark application with the USPTO. So why don't you take this one, Megan?
Okay, so not only does social media serve as an important tool to gather evidence for your trademark infringement or other cases, as I demonstrated earlier with the PayPal case, but brands have also, started to use facets of social media for all sorts of reasons. And one example we'll look at are hashtags. Hashtags in the last few years have become huge. They've transformed how brands and consumers interact with each other because now you can search by keywords and you can group all sorts of communications and topics, just by use of this single hashtag. So not surprisingly, as a result, since 2010, over 1,000 hashtags have been registered by the PTO. And thousands of more have actually been rejected for registration by the PTO. There's TMEP guidance issued in 2013 that said you can register a hashtag as a mark, but only if it is a source indicator. So like any other trademark, it actually needs to indicate the source of your goods. And it said, generally speaking, the purpose of a hashtag is not source indicating, but in fact, just to facilitate categorization or searching on social media. But that being said, there have been plenty registered, as I mentioned. Some examples, hashtag steakworthy for Logan's, hashtag blame mucus for Mucinex, hashtag make it count for Nike, and some other examples you see here. The specimens for all of these applications show the use of the hashtag in some way other than social media. And so that's important to note, because if you're showing that you're just using the hashtags, in any relation to social media, you're likely not going to be able to register it. And that's what happened here. There are a few examples. Hashtag skate, that was for skateboards, and the PTO said that's completely generic for skateboards. Let's see, we have pinup girl clothing. They were using, this is a tag for the clothing, and they were using hashtag pinup girl clothing, hashtag pinup girl style, right under a big block letters that said social media. And the PTO said, you're obviously just using that to direct your customers to social media. And then there was a brewing company that tried to register hashtag take the ride in connection with its beer. And the PTO said there, no, it looks like you're just trying to send your drinkers to Twitter. That one is a little bit questionable because there's no reference to social media. So perhaps if the company had fought it a little bit more, it could have gotten it through. But in any event, it did not get through. So, while the PTO has been very clear that you can register these hashtag marks, the courts have not been as clear. And in 2015, there was a decision in the Central District of California involving vaporizer pens. This was a complicated fact pattern we won't get into. There was a settlement agreement where both sides were allowed to use cloud and pen in different ways. And the plaintiff was not allowed to use cloud, pen together as a unitary mark. So what plaintiff did was post on Instagram a contest where it used hashtag cloud pen. Defendant said that it had breached the settlement agreement because of this. And the court made a definitive statement saying, trademarks do not serve as source identifiers. Hashtags, trademarks. Just send me away from here. Yeah. Anyway, let's start that over. Hashtags are merely descriptive devices, not trademarks. They don't serve as source identifiers. Unfortunately, the court did not clarify if it meant this particular use was social media, so it wasn't source identifying, or that all hashtags, cannot serve as trademarks. So there has been another court in the Central District of California that followed that with a definitive statement that hashtags are merely descriptive. It's possible that some other courts will clean this up, but right now it's questionable. That being said, hashtags has served as really important evidence in trademark infringement and in false advertising litigations. So regardless of whether they're registerable or not, to the extent that you're using another brand's name in your hashtags, that will and can be held against you in a trademark infringement or likelihood of confusion analysis. So if you're using hashtags, make sure they're not misleading, make sure they're not deceptive, and make sure they're not confusingly similar to another brand.
Sure, you have good counsel.
Always.
You want to talk a little bit about emojis? That's, something that we see a lot in social media, and we see brands using emojis. Where does that fall in terms of the law?
Well, emojis are everywhere these days. Not only are they on your phones and in your social media posts, but brands are using them all over the place. We have them in advertisements. We have them on product packaging, which Joe will show you some examples of in a bit. They have their own feature film put out by Sony. They're on clothing, and it's not just children's clothing. Actually, in recent years, both Chanel and Versace featured emojis very prominently in runway collections. So they really, I didn't believe it when I first read about it either, but they really are everywhere. And the question becomes, what type of intellectual property protection can you have for these emojis? There are two types of emojis. The first is the Unicode-Based Emojis, and these are the emojis that you see on your phone. So Unicode codes these emojis just like any letters you see. What Unicode does is put out a black and white outline that forms the basis for the emojis, and then the specific platforms that are implementing them add color and design. And that's why you see on your phone, if you have different phones, some of the emojis look different because the platforms implement them in different ways. And here are some examples. And then you have your proprietary-based emojis. These aren't based on Unicode, and these are independently designed, often referred to as stickers. They're your animal and food emojis, your Bitmoji, hi everyone, and your celebrity endorsement stickers. You have Ellen DeGeneres, Kim Kardashian, and of course, Justin Bieber. Everyone has their own emojis these days. Yeah, just for you. So, are these protectable? Can you just use them? What should you do if you want to use an emoji? The most obvious protection is copyright. That's because, in theory, these are two-dimensional works of art. But the question becomes, are they original? You have to prove that they're original to get copyright protection. And certainly, although there's a very low threshold for copyrightability, especially if you look at the first one on the slide, the face with no mouth, how original is that really? The smiley face next to it, not entirely original either, although there has been, other types of registrations for smiley faces before. So it is possible and maybe even likely that it would pass the threshold. Obviously, as you get more detailed, you meet the standard for copyrightability a little bit easier. But you have to consider, even if you get a copyright in these emojis, what is that really going to give you? It's got to be, there's so many emojis out there. it's very thin protection. So if you're trying to prove substantial similarity to actually enforce your registration, you're really going to have to show that somebody's using an identical emoji. And it's very easy to make some slight changes from these emojis, as you see from platform to platform. There also could be potential ownership issues. Nobody has really considered this, but if you think about the Unicode emojis, the platforms certainly say that they own their version of the emojis. Apple, for instance, has registered over 1,000 copyrights for each one of its emojis. But they, are the Apple emojis derivative works from those Unicode outlines? And so if you, in theory, want to license one of Apple's emojis, you also have to go to Unicode. Unicode is silent on whether it takes a copyright interest, but in theory, that is a design and it could own the copyright protection. Trademarks. There actually are registered emoji trademarks. And just like any other trademark, an emoji can be registered if it's source identifying. And so backing up a little bit, you're of course not going to be able to register your communications or the editorial uses of emojis, or even the ornamental use. So if you see a composite of emojis on a t-shirt, that's not going to be source identifying, so it won't be subject to trademark protection. But when you put an emoji in your logo, that might be protectable. And here are two examples of emoji logos that have been registered by the PTO. There have also been just individual emojis registered. You have the poop emoji for diapers and wipes, the heart eyes emoji for liquor, spirits, and wine. And then this one, technically this is not an emoji, this is an emoticon. But this is interesting because it was the subject of a declaratory judgment action filed by DVF a few years ago. DVF used this emoticon in connection with a collaboration with Gap Kids. And the owner of this registration threatened to sue, saying, that's my emoticon, you can't use it. DVF said that this is completely generic and you can't own it. The case settled very quickly. DVF went on with the collaboration. The mark is still registered. You be the judge of whether that would have stood up at court. A final note about hashtags and emojis, you really have to think about it, aside from the enforceability issues and the thin protection and whether these are really source identifying, emojis are a form of communication. They're just like words. You're not allowed to copyright, words or short phrases. And if you think about how you use emojis in your text messages, you use them in place of words. So you need to be careful, and all of us need to be careful when we're thinking about what kind of restrictions we're going to put on the use of emojis, because you might be limiting communication in a way, and that might also open a good fair use argument if you're ever being accused of improperly using an emoji.
Thanks, Megan. Let's just briefly hear from Joe, because I know Pepsi had a whole line of products that included the emojis, and I'm not sure how your team decided on which emojis they could use and how to go forward.
So, yeah, we, in 2015, I think it was, at least, it was the San Diego INTA meeting, I remember working on it there. We launched our own emojis. We wanted to brand them. We wanted, again, consumer connection with our emojis. And so we went about and launched various emojis that we offered online with our own app, but then also on products. And so our design group took the steps to figure out how to make it Pepsi. So if you look at the top in the white, between the red and the blue, we utilize that in our emojis. In the sunglasses, you'll see it, or you see it in the smile. You really kind of have to be looking for it. The colors are also, use of red, white, and blue. And then you see the top, the line that separates the red and the white. We kind of maintained that in as many emojis as we could, like on the soccer field there. And then when we did put it on a product, but kind of as I said with the Snickers example, we always used our Pepsi logo. So if you see in the middle, in the back there, on the back side of the bottle was always the Pepsi trademark, as well as the emojis. So that's kind of how we executed it.
Okay, great. We have a little bit more time just to do one last question, and that's this one's an interesting one. about offensive and scandalous trademarks, and Angela offered to take this one. There's so many examples of marks which are being refused, and what's the line, and society's become so sensitive. What is offensive? What can these brands do, and where are we going? So maybe you can give us some examples.
Sure, and I'll do it quickly. So who could resist covering the topic of scandalous material and getting to use certain words in this kind of forum? So before the most recent decisions out of the Supreme Court and the Federal Circuit, the Lanham Act prevented the registration of marks that were immoral or scandalous, or that tended to disparage people or groups. Those prohibitions have certainly been eliminated given the latest decisions. The way this had been applied previously is probably in this most famous example, the Redskins case, was to prevent the continuing registration of the Redskins mark, which the agencies determined, the TTAB determined to be disparaging to a substantial portion of Native Americans. And that decision stayed for a long time, and it had a lot of support. More recently, we saw the US Supreme Court dramatically change the law in this regard when the Slants case was filed. That case, of course, involved a band name, the Slants, that its founder wanted to trademark and register for purposes of taking back that term and eliminating its derogatory and derisive nature. And it was originally denied registration because it was disparaging to Asian Americans. And ultimately, the Supreme Court held that a restriction on a prohibition on registration of that kind of mark is content-based, that our First Amendment protects the expression of speech, that trademarks are don't serve just a commercial source identifying function, but they also serve as a means of expression, and that to deny a mark because it is disparaging to some is to deny speech that is offensive, which is what our Constitution does not allow. So after the Supreme Court issued that decision, applying intermediate scrutiny didn't reach the issue of whether strict scrutiny was required. It said it didn't pass muster under either strict scrutiny or intermediate scrutiny. The Federal Circuit recently took up the case of the fucked mark. I have never in a published decision seen so many references to this word in all of its various iterations, and it explored the history of the word and its connotations in society. And the Federal Circuit agreed, absolutely, this is considered scandalous under the law, but scandalous material cannot be prohibited either. It doesn't directly serve any legitimate government purpose to prohibit marks that we find offensive or scandalous. That this is not like radio, where we may have a legitimate substantial interest or compelling interest in protecting children from unsolicited curse words coming out over broadcast, that the government in registering a mark is not putting its imprimatur on the mark. It is not converted into government speech, and there's no reason not to allow companies that have every right to use this as a mark not to have the benefit of a registration. So where have we gone from here? At last check, I noticed about 120 pending applications or granted registrations for marks incorporating the word fuck, or some version of it. AF is very popular at the end of terms, and about the same number of shit marks, incidentally. They're tied at the moment. What will ultimately happen with these marks remains to be seen, because based on my survey of the pending applications, it appears that most of them are purely ornamental. So a lot of these applications were held up pending a decision in Brunetti, and may ultimately proceed now that the prohibition on scandalous material has been eliminated. But whether they'll ultimately proceed to registration remains to be seen, because they appear to be just logos on T-shirts and hats and that sort of thing, and or statements on T-shirts, and that would likely fail under the pure ornamentation. So we'll have to see how that all plays out. Even for those that have registered, there are several shirts that have those terms as ornamentation on shirts or other clothing items. It will be interesting to see what happens if they ever try to enforce the mark for live AF or some of these other marks that have been registered as against others for using those terms. So that's the current status. You know, we have the right to use all sorts of words in our marks, but no reason not to be mindful in which ones you choose.
Okay, because we're tight for time, I think what we're going to do is we're going to skip our last question, which might disappoint David quite a bit, because the last question was on, we were actually going to do a whole session on this question, but I think all we can say is that is certainly a trend we're seeing, and if we do an update session maybe next year, we can talk on that topic. But Elaine, I think you wanted to mention something before we go to Q&A.
Yeah, I just wanted to call out that if anyone is interested in learning more and hearing about brands and innovation, INTA is organizing a conference in March in New York on the 19th and 20th of March, and it's centered on brands and innovation, and it's 2 full days of very interesting panels and great keynote speakers from the Silicon Valley and elsewhere.
Great. Okay, so let's open it up to questions and answers. And if there are none, we'll go to break.
I'm just wondering, with all the changes that society and culture are sort of bringing to the IP system, is there anything that you're seeing that fair competition really needs of trademark law that we don't have? Because it sounds like we've had some cases that actually landed the right way, that's enabling competition, like the genericism case that you mentioned. And there are some areas that we can see there's gray that will need to be fleshed out. But I'm just wondering, did the panelists think there's anything right now that is broken in the trademark law that, given where we are in our sensibilities and the use of brands in culture today, we need to have fair competition working correctly?
I think in the area of fair use, there's room for improvement, and I know that a number of other panelists coming up in the day are going to address that, so we won't steal their thunder on that issue. But that's one area where I think we could benefit from some additional clarification.
Second, that was going to be a point, but we have a panel of experts this afternoon talking about fair use, and I do think that when we consider how we have evolved in terms of consuming brands in the digital space and the necessarily small and confined spaces where we consume logos and brands, there is a question as to whether the nominative fair use doctrine and even worse, outside of the US where fair use is much more limited, whether that is constraining us in terms of how we can continue to bring innovation and technology aspects. I think one of the other aspects, but maybe it's too controversial, is more, I struggle to see from a social perspective the how we further society with the scandalous, allowing the registration for scandalous or disparaging or offensive trademarks. And I think the one unfortunate consequence of that I see is a bringing of more disharmony among the global IP systems around the world, which have not and are not taking that type of approach rather than advancing some greater good.